A preliminary analysis carried out by the South African Law Reform Commission suggests that a handful of pre-democratic era laws are a variance with the Constitution in compatibility, social and economic, as well as constitutional developments deficient in some or other way was among the issues. A review of the legislation is now well underway. The Department of Justice and Constitutional Department is asking the public to submit comments by mid-January next year. Professor Shannon Hoctor is with the University of Stellenbosch and is one of the researchers working on this project. He joins us now. Very good afternoon to you. Thank you so much for your time. I suppose the obvious question is, why have some of these laws remained within our body of law for so many years after democracy?
Right. Well, with the transition to democracy, a lot of the old order legislation was actually kept. The reason for that was to ensure that the transition was as smooth as possible, so that the new structures could continue to function, that services could continue to be provided. And so that's essentially why it's taken as long as what it has. This is part of a broader initiative that is now taking place. So it's not just looking at the rules and laws that we're looking at in this issue paper, but it's actually a much broader analysis of all pre-democratic legislation to check whether it is still, whether it's constitutional, whether it's effective, whether it's necessary, whether it's relevant. And that's an inquiry which has been launched by Parliament, and it has now come to the Law Reform Commission. That's where I come in, with some of my colleagues, in order to examine some of these issues.
So how many of these laws are under review and could be repealed?
So there are a range of pieces of legislation. This particular issue paper, the one that I'm working with, just to explain, I'm part of an advisory committee to the Law Commission on this particular project, along with advocates Kasana and Semenya SC. And we've looked at, in order to make this as effective as and efficient as possible, we're really only looking at legislation which falls under the Department of Justice and Constitutional Development. And then within that, because there's a huge range of laws which fall under that department, just the laws, expressive laws that are contained in the, or rights, I should say, which are contained in the Constitution. So the right to religion, the right to assembly, the right to association, the right to expression, the right to political rights, all of those are included in this particular issue paper that we are busy dealing with.
So when it comes to processes of addressing these outdated laws, what does that look like? I mean, as I look at some of the laws, there's the Righteous Assemblies Act 17 of 1956, right, which still contains language deeply rooted in racist apartheid past offences, and a section of it I know was declared unconstitutional by the Concord in a matter between the EFF and the Minister of Justice.
That's correct. And that's exactly why it's so important for us to engage in this particular investigation into all of these laws and to test them against the Constitution and the standard of the Constitution. So essentially, the process is that we go to a process of public consultation, so that everybody has a say, so that everybody can give their view. That information is then gathered, and it's worked through by us as an advisory committee. That is then taken to the Law Reform Commission itself as a statutory body, and then input will ultimately be given to Parliament for the purposes of making the necessary changes to the legislation.
How does the public get involved?
So the public will get involved, and this is democracy in action. So it's an exciting process, and we really encourage everybody to get involved. There will be soon workshops and other meetings, public meetings will be announced where these issues will be discussed in some detail. And so we welcome public to get involved in that. Also, of course, they can provide information, questions, comments, suggestions in relation to any of these issues, as I say, relating to the expressive rights in the Constitution and the criminal laws that affect these rights and that limit these rights. And that can be done directly to the Law Commission. so by way of email or by post. So that can be sent directly to the Law Commission, and we'll take the information and work with that.
Yeah. Okay, we're going to have to leave it there for now, but thank you so much for your time, Professor Shannon Hoctor from Stellenbosch University, speaking there about apartheid-era laws which are